Well, good morning, everyone. I'm Matthew Smerdon. I'm Chief Executive of the Legal Education Foundation. I'm also a lay member of the Civil Justice Council, and I'm chairing this next session. Our starting point is that one imperative, crucial element of a step change in access to justice is having better information about how the civil justice system operates. And it was in the context of successive projects and issues that were coming in front of the Civil Justice Council that there was repeated evidence that there were gaps in key information. It was very striking and has become sort of increasingly so. And of course that matters because it presents such a challenge in terms of understanding how the system's operating, how different people are progressing through the system, and what impact that might be having on outcomes. So it was especially welcome to hear the MR's personal commitment to advancing the effort relating to collecting information. And as the process of court reform and digitisation continues, it provides both a catalyst and an opportunity to learn and to improve. So we have three terrific speakers for you. First will be Dr. Natalie Byrom, Director of Research and Learning at the Legal Education Foundation. She's going to describe work that she's done with stakeholders from the UK and actually from across the world to understand what information should be collected through reformed justice systems. We're then going to hear from Her Honour Judge Lesley Newton, Designated Family Judge for Greater Manchester, who's going to talk to us about how the family justice system has embraced the capture and use of information to improve outcomes for litigants. And that's been done particularly through projects such as the Family Justice Observatory and Plato. And then we're going to hear from Matthew Bell, who is Head of Legislation at the National Archives, to talk about how there have been benefits accrued from digitising the statute book work done by the National Archives. There'll be then a chance to have some questions across the panel, but before that we'll go straight into hearing from Natalie. Thank you.
Thank you so much, Matthew, for that introduction, and it's a pleasure to be on this panel alongside Her Honour Judge Lesley Newton and Matthew today, so thank you. At the Legal Education Foundation, we believe it's vital that people are able to understand and use the law, which means having timely, authoritative information available about the processes that people use to secure their rights and the outcomes they secure when they do so. To date, the civil justice system has been something of an informational black hole. Successive initiatives designed to explore the crucial and somewhat basic questions regarding the types of individuals and organisations that initiate claims, the frequency of the use of certain types of legal orders, or the impact of certain types of legal decisions on downstream consequences for individuals, have been unable to draw effective conclusions simply due to the paucity of information available. This matters because it drastically impedes attempts to, for example, design targeted legal education that can ensure that the right disputes make it before court, or to identify people who might need additional support to secure a fair and effective hearing. The ongoing programme of court reform, which aims to digitise the civil justice system, offers an unprecedented opportunity to deliver a step change in access to justice by improving both the quality and the quantity of information we have about the way the system operates. The reform programme provides both the catalyst and the digital infrastructure to improve the way data on the operation of the justice system is collected and address systemic deficiencies in the way in which important legal information is disseminated to court users and to the public. This opportunity cannot and must not be missed, and it's so fantastic to hear from the MR about his personal commitment to advancing this agenda. Thank you. It's also imperative that judicial leaders are able to access information that enables them to ensure that digitised processes meet the criteria they set out for them when the programme was established, particularly in relation to maintaining or improving access to justice. It was for this reason that in 2018 I was seconded to Her Majesty's Courts and Tribunals Service as advisor on open data and academic engagement to advise on the development of the information architecture around reform, and in particular to specify the information that reformed systems should collect to facilitate an understanding as to whether reformed services deliver their stated aim of maintaining or improving access to justice, particularly for those who are vulnerable. The output of this secondment, published in 2018, was this report, Digital Justice. This is my QVC moment. It's available on our website, which sets out a 29-point plan for putting access to justice at the heart of the data strategy HMCTS are developing to support their ongoing programme of court reform. As Matthew's alluded to, in developing the recommendations contained within the report, I consulted with over 60 expert stakeholders from the judiciary, civil society, the profession, academia and beyond, and published interim findings which were subject to a period of public consultation to arrive at the recommendations. There's insufficient time here to present the recommendations in detail, but in summary, it was held that reformed services should routinely collect better information on the individuals who use the justice system, particularly data that enables conclusions to be drawn regarding the compliance of new systems with the public sector equality duty. The report proposes a list of just 13 data points which, if collected, would drastically improve our understanding of the vulnerability of users of the justice system. This data should be requested from users on an optional basis and held separately from the case file, in the same manner that data collected through equality and diversity questionnaires routinely used by employers is used and stored. There's also a need for better information on the cases that are brought before the justice system. What types of claims are being filed and what types of claimants are filing them? This would enable us to better understand whether particular types of actors are driving particular types of cases and particular types of outcomes. For example, are bulk claims brought by utility companies leading to higher levels of default judgment? And what might this suggest about the efficacy of existing statutory schemes around debt forgiveness? How could targeted legal education improve outcomes for claimants and defendants in this context and reduce pressure on the justice system, which we all know is overstretched? Better information on whether or not reformed processes deliver against the legal definition of access to justice, which, when you examine the existing case law, consists of 4 components: access to a formal legal system, access to an effective hearing, access to a decision in accordance with law, and access to remedy. And better data on outcomes. Where do people drop out of the system? At an aggregate level, which sort of people drop out? This information would not be definitive, but it would better equip us all to understand the civil justice system that is so crucial to the rule of law and the functioning of our democracy. If published at an aggregate level, it could improve trust and confidence in new processes and help reform meet their business case. Crucially, it would provide us all with the insights we need to develop initiatives and interventions capable of bringing about a step change in access to justice, which we all agree, even after 8 years, is still so desperately needed. There's much we can learn from the work that was led by the judiciary and the family justice system in response to the Family Justice Review, which recognised the paucity of data as an access to justice issue in and of itself, and also the National Archives, who've pioneered and improved access to legislation, and I'm really excited to hear from them.
Thank you very much, Natalie.
Good morning. I've been asked to describe essentially 3 categories of information which the family justice system uses. The first is what might be described as basic administrative data, which secondly can be developed into something more sophisticated. And thirdly, and this is the exciting bit, the role of the Family Justice Observatory in enhancing decision-making within the family justice system by using research and data. So firstly, the basic stuff, how many applications, how long is it taking a case to get through the system, is the stock of a particular type of case rising or falling? That's all been available to leadership judges for quite a long time, certainly in the family justice system, and I think equally in the civil justice system. It is paid very close attention. And in terms of access to justice, it enables me and senior judiciary above my pay grade to argue, for instance, for a business case for an additional judge in a particular court, or that a particular court shouldn't be closed, or that we need to recruit 50 more magistrates. So it's all quite important stuff. But as Natalie points out, the scope for increasing our understanding by gathering more basic data with the onset of digitalisation is going to be fascinating. What I would say, if I may respectfully say, is don't be too frightened of digitalisation. The family justice system has been operating, certainly in Greater Manchester, about 5 years on electronic files and bundles. And the process of divorce applications being made online has been a tremendous success. HMCTS used to return over a third of divorce applications. I think we're down to something like 2% at the moment because they are filled in so well. I give a mention to our support through court volunteers in Greater Manchester who've helped huge numbers of applicants to fill those forms in. The barrier to justice is not the digital form, the barrier is the sheer cost of making an application for a divorce. So, more recently, that HMCTS information has formed part of a major data sharing exercise within the Ministry of Justice. I haven't got time to describe it all to you now, but it's about 600,000 children who entered the family justice system between 2010 and 2016. And it enables us to make comparisons at a regional level, at a designated family judge level, but also at an individual local authority level. So my friend Carol Atkinson, who's the designated family judge for East London, has a very similar demographic to me in Greater Manchester in terms of level of deprivations. We each have very high numbers of applications from 10 local authorities. And when we compare our data, which we now can do by the device that's called Plato, which arises from the data sharing, public law applications to outcomes. The striking findings include that if you're a child in my area, you're 2.5 times more likely to be made the subject of a care application than if you're a child in East London. If the local authority does make an application for a care order in Greater Manchester, 57% of the time, that application results in a care order. In East London, in only 37% of occasions. Similar huge discrepancies in the use of supervision orders. And interestingly, in Greater Manchester, there's a clear link between the level of deprivation and the rate of care demand. So Salford, my poorest authority, issues a lot of care cases. Trafford, per head of the population, very few. There is absolutely no correlation in East London between care demand and the degree of poverty in a particular area. So all this is very interesting. It doesn't tell us what is the right level of care applications. It doesn't tell us why the variations may exist. There's all sorts of possible interpretations. I have previously said it's the northern powerhouse leads the way in child protection, or alternatively, it could be just it's grim up north. But we have that comparative data. That stimulates debate. It's making us ask questions and explore hypotheses. Coming to the Family Justice Observatory, Natalie's already referred to the Family Justice Review. The observatory's gestation has been very slow. The review was in 2011. We've eventually secured substantial funding, £5 million, thanks to the generosity of the Nuffield Foundation. The board is chaired by Sir James Mumby, until recently the president of the Family Division. You can find out everything about us by Googling Nuffield, the Family Justice Observatory. But essentially our aim is to support better outcomes for children in the family justice system by improving the use of data and research. There are umpteen different strands of work. I think time only permits me to give you one illustration, which is a recent piece of work called Born into Care. Because anecdotally, many of us thought we were seeing a rise in the number of applications for newborn babies to be removed from their parents, but there was an absolute dearth of evidence about the scale of any problem that might exist. The researchers calculated that the number of care cases involving a child under the age of 1 was 26% of all of the applications for care orders. And of those, 36% of applications were brought in the first week of life. That the number of such applications had more than doubled over the 8 years between 2008 and 2018. At local authority levels, there is one heroic authority that made applications for 159 children per 10,000 live births. There are some London boroughs who made almost no such applications. There was an average in the northwest of 30 cases per 10,000 live births. In London, the figures are around 18. Why are those extraordinary discrepancies? The impact of that research, and I'm using this as an illustration, the next stage is to try and challenge, as we hope each piece of research will do, the system and inform policy. For instance, we want some guidance from the DFE about pre-birth assessments. We want to look at the variations in demand for these orders. At a local level, the team who did the research are running a whole series of workshops across the country to say to individual local authorities, why are you making so many applications? Or why are you making so few? What are your resources in terms of mother and baby foster homes or in terms of residential homes? Challenging individual authorities on their practices. We need to develop better mechanisms for getting all of this information shared with busy social workers who don't have time to read a 100-page report. I'm conscious that I'm about to exceed my time. I'm sorry, I'm very enthusiastic about this. I could talk about it all day. I do apologise. If I, at risk of teaching my grandmothers to suck eggs because I abandoned my civil authorisation many years ago, it seems to me that Natalie's work is the beginning of looking at a task which we've tried to undertake in the family justice system, which is to say, what do we know and what don't we know about children entering the system, about the litigants who choose to litigate in the civil justice system, and perhaps more importantly, those who don't choose to litigate because of the barriers to their involvement. We have beautiful infographics, what we know, what we don't know. I think that's a very interesting piece of work for the future for the civil justice system. Thank you very much.
We'll go straight on to
Well, thank you very much. It's great to be here. It's a subject, access to justice, is very close to my heart, so I'm looking forward to a good conversation. I'm sure everyone in the room will be familiar with the principle that ignorance of the law is no defence. But I think they'd also agree that ignorance of the law doesn't really help very much if you can't find the law somewhere. It's already been referred to Lord Neuberger's comments that access to justice requires the law to be made available to people. You need to be able to find it. And that is what, at the National Archives, it's our responsibility to ensure that legislation is published. Traditionally, that's been done via print. We still do the traditional print publication, and all of our laws that we publish do find their way into libraries across the country. But I think it's fair to say the most, by far the most well-used channel for accessing legislation now is on legislation.gov.uk, and the website that is the official source of UK legislation. So I'd like to talk about how the digitisation of legislation has really helped us to deliver on what we consider to be our key priorities and hopefully aid access to justice. And we're responsible for three main things. We look at we're involved in the supporting government in the drafting, registration and publishing of legislation. So new legislation that is published is available first on legislation.gov, and we provide the tools that are used by legislation drafters to make that legislation as quickly and efficiently as possible. And that, again, it means that the law is available to the public as quickly as possible. A good example, if I may use the dreaded B word, recently was around a statutory instrument that was used to amend exit day, moving it from October the 31st to January the 31st. That required an amendment in legislation. And our digital processes meant that statutory instrument was on the website in less than an hour after the minister actually signed the into law. And it was interesting to see straight away the debate and discussion on Twitter that SI being available then triggered. So it's good to see that people are using it. We also are required, as I said, to publish the legislation in a way that is accessible to as many people as possible. Legislation.gov.uk is certainly in the National Archives by far our most well-used on their digital service. We get over 500,000 users or visitors a week, and the numbers have increased sort of exponentially over the last few years. And we also see it as our duty not just to publish the legislation and make it available, but to help people to understand it. We know that legislation is a complicated area for the public, those without legal training. It's often impenetrable. And we have the facility with the website with our reach and our wide audience to hopefully help people to understand the legislation so that they can use it themselves. So in terms of sort of our reach and the accessibility of what we have here, we have a huge amount of content that maybe people are not aware of how much we have. We have sort of thousands of Acts of Parliament, tens of thousands of statutory instruments. And again, recently in response to the challenges of EU exit, we've added all European legislation to the service as well. So that was an additional 150,000 documents added to the pile, which means for the first time that all of the legislation that applies to the UK citizens is now all available in one place. And hasten to add, it's for free. The services that are available and used by most professional lawyers are charged. They're quite expensive. They're very good services. They serve a need, but for the general public, it's out of their reach. We're very keen to make sure that our legislation is open and as easy to find and to reuse as possible. So as I said, our user statistics, we see 500,000 people a week. But who are these people? The fact that we have a website means that we can analyze our users a little bit. We can turn the lens back onto them. So what are they looking at? What legislation is popular, if that's an appropriate term? We can also ask them questions. We regularly do surveys of our users, and we can find out who they are. And we know that about 40% of our users are professionals, but not legally trained. Only about 20% of our users are legal professionals. About 20% are just members of the public doing some research off their own bat. Most people are using it for work, but the things they find difficult, we can ask them. They don't understand fairly key concepts of legislation. We know that they don't understand issues, concepts such as commencement or extent, the idea that a piece of legislation can come into force at different times and in different places. So the law may be different in Scotland or applied differently in England as it does to Wales. These are concepts that I think most legislation users are not familiar with. And again, we seek to try and find ways to illustrate that and guide people to the information they need to understand the law correctly. We also know they really want the law to be up to date. So again, a lot of people I think don't realise that once a law is passed, it isn't set in stone. It constantly changes. It's updated over and over again. So the Companies Act, which is by far our most well-used piece of legislation, that's been amended hundreds, if not thousands of times. It's amended every year. So if you need to know what the law is that applies to you in terms of the running of your company, it's no use just looking at the law as it applied in 2006 when that act was passed. You want to look at it as it stands today. Or maybe you want to look at it as it stood 4 years ago, because that's relevant to maybe the case that you're involved in. So for each of these pieces of legislation, we have spent the last 10 years bringing that legislation up to date. It's been a long and lengthy process. We know that we haven't always had the best reputation for being up to date over that time, but we're now in a position where 99% of primary legislation is up to date on the website, and we're moving on to secondary. The other thing that is helpful in terms of law being digitised is that it allows us to analyse the statute book in ways that have not been possible in the past. We know how many pieces of legislation there are. We know how many pieces are in force. We know how many times they've been amended. For example, in preparation for EU exit, the legislation that's been passed over the last 18 months to update the statute book there has generated another 80,000 amendments. those 80,000 amendments will come into force on exit day, and we know exactly which documents are being amended. We can see the spread across government departments, who's been doing the most. So you can ask some quite interesting questions. And we can also analyse the text. Because the legislation is held in XML, you can run queries across the statute book and look at patterns in language. You can see how the law has changed, the style of language that has been used. And we're developing tools that will help researchers to really get an understanding of how the statute book works. For example, the subject of vulnerability has already been raised. Did a research the other day on the use of the word vulnerability in legislation. Didn't really appear anywhere except in relation to the vulnerability of dams and structural buildings. But in the context of vulnerable adults or vulnerable people in society, it was a concept that wasn't really introduced into legislation until the 90s and has increased over time. So the research opportunities of having a digitised statute book, I think, are really, really interesting. So I won't go any further on that, but it'd be really useful to hear if anyone has any questions on what we're doing, because we're really interested in knowing how we can do a better job and how we can make the site more user-friendly.
Great. Thank you very much for a terrific presentation. We've got time for just a couple of quick questions before the break. You've all outlined the case for and the benefits of collecting better information. Are there any risks to access to justice of doing this? I'll come to Natalie, Lesley, and then Matthew.
I think, so this is a question that we faced a lot in the context of the report. People were especially concerned that when we spoke about adding the additional questions on user characteristics at the front of systems, that could present a barrier to access to justice. And we've addressed that in two ways. Firstly, they're optional, so anyone who doesn't want to answer them can click through. And two, I think from the user testing that's been done in this area, people are increasingly used to being asked these questions, and actually it hasn't posed the barrier that people would suggest. I would argue that the much greater threat to access to justice is developing these new systems in an untransparent way and not publishing information that enables people to know that people like them will be treated fairly in digital systems. There's a good body of research to suggest that when new processes are introduced and people don't know what they look like or feel like, what they look to instead is information on outcomes and information on how people like them fare. And I think really there's a much bigger threat in not collecting this information than there is ever in collecting it.
Thank you. Lesley.
Certainly the information that the Family Justice Observatory works from is our basic population data is from CAFCAS, and that's all then very carefully curated and entirely anonymised, and we have a partnership with the Sale Data Bank at South Swansea University, which is, I think, one of the absolute leaders in this field. So I don't think there's any risk to any individual of them being identified, and the benefit to researchers of having that kind of rich data, especially now with the Welsh Government have given us access to all of their data, health, education, local authority, and we can link all of that in an anonymous way. It's such a rich and accessible resource for the research community, and I don't think does anybody any harm.
Thank you. Matthew, would you like to say anything?
Okay, so I mean, obviously in terms of data collection, that's not really something that we specifically do at the National Archives or to publish legislation, but I would say that the risk is in unintended consequences of you can bring in all this data about who's using which piece of legislation, or how successful different approaches to litigation are. But the risk goes always around overvaluing what you can quantify and missing the devil being in the detail. And I think it's very easy to look at everyone's looking at this piece of legislation and giving that all the attention, but that doesn't necessarily mean it's the most important piece of legislation. So you've got to be careful you don't get too dazzled by the possibilities of data.
Great. And obviously there's a particular focus on courts, but I'd be interested to know, how has progress, particularly Lesley, and then we'll come to Natalie, how has progress on collecting better information enabled people to intervene sooner in issues and then prevent the arising of sort of greater human and economic costs?
I don't really think we've got that far yet. I think we're still in quite early stages. I think what we're doing is reflecting on what has happened within the family justice system over, say, the last 10 or 15 years. I don't think we're yet in a position where we can make predictions.
Okay, and Natalie, you'd like to say anything about that?
Yes, so there are two examples, one which requires unsophisticated data and one that requires more sophisticated analysis. So at the unsophisticated level, merely having better information about who is filing claims and what are the responses to those claims when they're filed gives you vast opportunities to intervene earlier to stop cases that shouldn't be coming to court. And the example that I gave was around utility companies' claims. One of the things that when there was more legal aid available, like lawyers would frequently be able to identify, this company repeatedly files claims and the claimants don't respond, or they'd be able to pick up that information. As funding for the advice sector has disappeared, that kind of information ecosystem has been lost. But if you're able on a routine basis to identify, who are the biggest drivers of default judgments in the justice system, and then look at the reasons why those default judgments are being driven, you could work with the utility companies, for example, to ensure that they're making full use of the statutory relief schemes that they have. One other approach in the way that this data could be used is, and this requires much more sophisticated analysis, is being able to link data from the justice system with other sources of administrative data appropriately and securely in facilities like SAIL that Leslie's alluded to. And in that way, you're able to build a better picture of people's journeys into the justice system and therefore identify in a better, more evidence-informed way where the opportunities might be for delivering targeted legal education or information that could stop them from ending up there in the first place. And I think these are the real sort of potentialities. And Lesley, you're being too modest, because I think the implications of the work that you've done, it's giving you the basis to go and have conversations with social workers and with local authorities and to try and actually understand why it is the case that there are these disparities, and hopefully, understand those reasons if they're legitimate, and if not, correct for them. Yeah. So that's the real potential of it, I think.
I think what I'm saying is I don't think we've got any evidence yet that that's working, but it should.
Yes.
Yeah.
Matthew, any last word?
Again, going back to what I said right at the beginning, that access to justice is helped by making it as easy as possible for people to find the information that they need. And to do that, you really need to understand their problems and their user needs. And that's something I would encourage people to do.
And
Final word.
Sorry, if I may, Matthew's being far too modest when you look at the scale of what legislation.gov.uk has achieved in such a short amount of time in terms of creating. When I was interviewing stakeholders for this report, legislation.gov.uk was the one part of the legal information system architecture that everyone was happy with, and that's because it's free, it's enriched content, and it's really well designed and put together. And as a provocation, I'd certainly like to see you take over case law too.
Lesley, any final comment?
I think it is just trying to pin down what you know, what you don't know, what you need to know, and then work out how to get that information.
Great. Well, thank you very much to our speakers. It's been a very thoughtful.
And huge thanks to Matthew from the Civil Justice Council for chairing that. Time now for tea and coffee. We'll take 20 minutes on this, so back at 25 to 12. Can I ask that 25 to 12, yeah. Can I ask that everybody tries to meet somebody that they haven't met before over tea and coffee? And when you come back in, think about sitting somewhere differently, not at the back, not at the sides, but right in the mainstream.